So good morning from my side. My name is Franziska Wöhm. I'm the organizer of this panel, and I'm really thanking you for coming this early to this to our panel on the Law Enforcement Directive. We will have 4 presentations. Uri is on his way, but schools are on strike, so the kids have to be somewhere in Brussels. But he will join us in 10 minutes. Yeah, don't worry. I will briefly present all the speakers to you, and as we are, or as we've published the law enforcement commentary last year, Eleni and me, we wanted to do a panel to update a bit on the case law regarding the Law Enforcement Directive and also discuss the future scope and maybe do we need a reform or something? Do we have new ideas on the Law Enforcement Directive? Yeah, so first, the first speaker is Eleni Costa, my co-editor, or the first editor of this commentary, and she's, of course, a professor in Tilburg, doing data protection since a lot of years. So we know each other since we did the PhD, I think. And she's, of course, involved in numerous EU and national research projects, as well as in the AI application, I think, in the Netherlands. She will talk about the case law on the Law Enforcement Directive, new cases, and the principles which were discussed by the Court of Justice. I'm happy to see that people are joining, so we should leave them. Just leave the door open, maybe. Yeah. Perfect. The second speaker is Juraj Seifert from the EU Commission. He also did a PhD relating to law enforcement last year, and he works at the DJ Justice. Then he will speak about the maturity of the LET and the application report in 2026. Then we will have Teresa Quintal from the European Parliament, the Secretariat of the LIBE Committee. She is an administrator there, and she also completed her PhD in Luxembourg, where we know each other. We are all authors of the commentary. This is why we choose this panel and also the selection of speakers. All the speakers you see here, they published also something in the commentary. Exactly. And last but not least is Nora Newlydon, and she will talk about the EU-UK adequacy decision, where we are now. She's the director of the Information Law and Policy Centre and senior lecturer at law at the University of London's Institute of Advanced Legal Studies. So I think I will hand over to Eleni for the first presentation, an introduction, and the LED case law. Thank you.
Thank you, Franziska. Thank you all for joining. As this is a panel, we just decided that we will throw some information out to you, and then we hope to have some dialogue between the panelists and the audience. So when Franziska and I decided to embark on this, that was just after COVID. No, just before COVID, because we were ambitious and we were both pregnant at the same time. So that's what people do, decide to embark on a huge project. So it was a huge task with a lot of late nights and exchanges of, I counted thousands of emails in the end between us and the editors and the contributors. And anyways, it was a big thing, and we are very happy to see that that the people that are relevant in the field have actually embraced it. So one of the questions we receive, although it was only published last year, is when are you going to update it in order to include the case law of the Court of Justice? Because when the commentary was prepared and published, the Court of Justice was mainly busy with cases on the GDPR, exactly because the LED was a directive and it needed to be transposed into national member states, and then courts needed to, there was some time until issues arose, and courts would send a request for preliminary ruling to the Court of Justice. So that it makes sense that we see case law from the lead flowing out of the Court of Justice later than the GDPR. So now transposition is obviously completed with its goods and its bad points. This is something that we're going to be discussing later on during this panel. So what I decided to do as a start of this panel is to look briefly into what the Court of Justice is focusing on in its judgments, which means what national courts are mainly interested in. So I'm going to focus especially on the last year and a half in the case law, because we had a similar panel last year. For the ones that joined last year, we don't want to repeat ourselves, but still the line of cases remains mainly revolving around the data minimization principle, so the interpretation of the data minimization principle, and I will explain a little bit more, as well as the processing of sensitive data in the context of the Law Enforcement Directive. So for the ones that are interested in details, in January 2024, the Court of Justice decided on a case with number 118 of 22 NG, where the court was actually asked to interpret the data minimization principle in terms of retention and deletion periods of data. So in national law in Bulgaria, the law for a specific, quite broadly defined range of criminal offenses, the national law would foresee that the data would be retained forever until the death of the convicted person. So an applicant that was convicted for an offense that was only bore a sentence of 1 year, he found that this was not a reasonable provision in the national law. So he made a complaint at national level, which led to a request for a preliminary ruling at the Court of Justice, asking whether this was actually compatible with the principles in the assessed in relation to the Charter. So both what types of information was retained, as well as the length of the retention period, they were examined by the court, and we see the court saying, well, actually, we don't consider reasonable a retention period until the death of somebody. National legislator needs to have criteria. Of course, the Court of Justice did not say it should be X amount of years. It's normal, but it made it clear that the national legislator should have criteria in order to establish the duration period as well as the types of data that are retained. That should be proportional. So again, we see a very strong focus on the proportionality principle. In April last year, in the CG case with number 548/21, because I see some students here and I know they love the case numbers, the court discussed the fundamental question on the conditions under which the competent national authorities can access data that are contained in a mobile phone for purposes of combating criminal offenses. In general, with the lead, and also with regard to the obligation to inform the data subject after the completion. Here's Yuri. After the completion of the investigation. This case has to do with the conditions for accessing data. And it is interesting because we see cases like this in jurisdictions within and outside the European Union. The police seized the phone during the arrest and attempted to access the content of a mobile phone without previous authorization from a public prosecutor or a court. CG challenged the lawfulness of the seizure and the compatibility of this practice with the rights to privacy and data protection. In the analysis of the court, key was also once again the interpretation of the data minimization principle, that the access to the data that are collected in this context should always be adequate, relevant, and non-excessive, and requested, again, a very thorough proportionality assessment in these cases as well. The VS case that was decided in November 2024, that is C80 of 23, the application, focused on the processing of sensitive data, and the court examined strict necessity of collecting special categories of data. The case was about a person that was convicted of tax evasion, and she was requested to submit fingerprint DNA material as well as her photo. She said this is not proportionate to the offense that I have been accused and later convicted. So there are quite some complexities in this case. So the court required that the CJU repeated its position that there should be a prior authorization by a court if the accused does not consent to the collection of all this material. However, it also brought also a lot of requirements with regards to the national laws. We have also some cases pending, and again, we see that one of them coming from Bulgaria, it's C number 5 of 25, relates again to data minimization, and a case coming from France, C 371 of 24, again relates to the processing of sensitive data in the context of the LED. So actually, we were discussing with Francisca and said, okay, if we want to update the commentary, we will probably burden 2 or 3 authors with mainly altering and enhancing their contributions, while the rest is not. So we are thinking of ways how to do this. But before I close, because I know that time is moving on, we see the LED as a very important piece of legislation. However, it is not independent of the rest of the data protection legislative instruments in the European Union. So often a case that reaches the Court of Justice revolves around the GDPR and has some questions on the LED, depending on the case, of course. So there is a case pending where, once again, the problem is the scope of application. Do we apply the GDPR? Do we apply the LED? Do we apply on one part of the processing the LED and on another part the GDPR, the LED? So it is interesting to see what the court says in this case, is trying to delineate and draw a fine line, a clear line actually, between these. Also, the issues relating to access to retained data cannot be seen completely separate from the Privacy Directive. We know that in 2017, the European Commission published a proposal on the amendment of the Privacy Directive and the adoption of any privacy regulation after an impressive number of 7 years of failed negotiations. Am I allowed to say that? Well, not very successful, to be politically correct. The European Commission decided to withdraw this proposal, so we are waiting to see what the new piece of legislation will be about. At the same time, knowing that the European Commission also wishes to submit some kind of legislative proposal for data retention issues. So we had the 2006-24 directive on data retention that was repealed that was annulled by the Court of Justice. With a lot of turbulence, we can have another. I mean, we've had several panels on this. We can have another one. Just to conclude, that the high-level group on access to data for effective law enforcement published its recommendations in spring last year, focusing on a number of issues relevant to access, including retention. So it's interesting to see what kind of legislative developments we will get next to the LED and how this also will, and if if and how they are going to affect also the development of the Court of Justice jurisprudence. Thank you.
Thank you so much, Eleni. I think you got a first overview. I would propose to do questions later and involve the public after. Maybe we heard all these updates. I'm happy that Yura is here. So you, thank you. So you are the next speaker, Yura, if you want to take over. Thank you.
Yeah, sure. First of all, sorry I'm late. It was for reasons. And I wanted to first thank the CPDP for the opportunity for me to again speak on a panel dedicated to the LED. And of course to Eleni and to Francisca for inviting me to this particular panel. It is because it's not given, this is a great privilege for me to be able to keep doing this and that people are not bored of me. It became a tradition. It's very important to me personally because actually this is how I met my wife back in the day when I was still handsome. So that's where this is really something special for me, I have to say. First of all, I wanted to say that I'm here with two hats because I actually have two jobs. I work for the DG Justice of the European Commission Data Protection Unit, but I also work for the Vrije Universiteit Brussels, where I'm a postdoc. And in both cases, I'm only expressing my personal views that cannot be attributed to the institutions that I'm working for. So first, I will put my European Commission hat on. Because, why? Because I'm part of a team that is full steam ahead preparing for the second LED application report. And that report is in accordance with Article 62, paragraph 1 of the LED, due in May 2026, so exactly 1 year from today. If you were following the LED from its conception, or at least a bit longer, at least the last 4 years, you might remember the first application report that was published in 2022. And I know that some of you were kind of disappointed with the content of that report or the lack of it. But to be fair to the Commission, you have to acknowledge at the time that the LED experience was very limited in 2022. It was a very big change compared to its predecessor, which was called Framework Decision 2008-977. And that change was not automatic in 2018 when the LED transposition deadline expired, because most of the member states were actually late with the transposition. And then even more late with practically applying the LED on the ground, and then supervising and enforcing the LED, issuing guidelines, etc. So even though the Commission was very, the Commission didn't have any delays in launching infringement proceedings against member states who did not transpose the LED, it's still, even under that pressure, the member states mostly transposed it in 2019, 2020, the latest in 2021. So obviously also the DPAs were overwhelmed with the GDPR, so they were focusing mostly on that. So obviously the experience was very limited. And now for the second report, I think we have many more data points, many more experiences. So my hope is that, and everyone who works in my team hopes the same, that the new report will actually put much more meat on the bones and that we will understand much better what works and what doesn't work in the LED. So to announce the report, I would like to explain that the report will be constructed on 4 main building blocks. So the first building block is our own sort of in-house Commission conformity assessment, which is a very long, tedious exercise where we analyze LED article by article and check how the LED is transposed and how its provisions are transposed in 27 member states. Some have done that in a dedicated piece of legislation. Some have done it in a law that at the same time also implements the GDPR. There are transposition provisions in sectoral laws, in Police Powers Act, in criminal procedural codes, other types of more specific laws. So all that was analyzed thoroughly, as I said, article by article. Part of this analysis was outsourced, and then meetings with member states, discussions, trying to understand how their criminal justice systems work, and they are all different from each other. This is not harmonized like data protection is. This is the year, 2025 is the year where we finally hope to complete the picture and have the entire matrix, understand all the transposition techniques, and how exactly every national criminal justice police system works together with the data protection law, and finally have a decision or understanding on what are the remaining big concerns that the Commission has about transposition in every member state. So that's the first building block. The second building block is a very large fundamental rights agency study. That study should be finalized by the end of this year as well. And it is predominantly an empirical study, focusing on collecting qualitative data about functioning of the LED, again, in all 27 member states. So what FRA is doing right now, they are combining this desk research with interviews with law enforcement officers from competent authorities, data protection authorities officials that are in charge of supervision and enforcement of the LED, police, prosecutors, data protection officers. So they basically interview the data protection officer of a police force or public prosecutor's office, two police officers, so the ones that are really, applying the LED on the ground, one prosecutor or one investigative judge, depends again, on a criminal justice system in a member state, and one official from the Data Protection Authority in charge of the LED. So basically, it's 5 interviews times 27 member states, fully confidential. The Commission will not get any personal data from those discussions. And the goal is really to tease out data protection on the ground. So if there are any law enforcement officers in the room who got an invitation from FRA or FRANET to participate in these interviews and felt like you are too busy and don't really have time to discuss, I would ask you to let yourself be interviewed, because these are really important data sets that would help us understand better how the LED works or doesn't. And so that's the second building block. The third building block is information we are trying to collect through the European Data Protection Board. And there we very much focus on quantitative data about the LED. So I don't know how many DPAs, how many complaints DPAs receive, how many, on which topics, how many indirect access exercises they receive, Article 17 requests, that kind of stuff. So how many times they use their powers from Article 47 LED, especially it's interesting to know what kind of corrective powers, fines they impose, etc. So we are now finalizing these questions that will be sent to the EDPB, and we hope to get their reply also by the end of the year. And the fourth building block of the report is the usual feedback we always get through standard tools that are out there for the Commission, such as call for evidence, public call for evidence, input we get from the European Parliament, from the Council, from the expert group on GDPR and LED. So we are obviously counting on that as well. When it comes to these discussions with stakeholders, so far we have not received any calls for amending the LED, so that we don't have any intention to do so at this stage, but this is of course premature. I cannot commit in that sense. I'm just saying that so far we didn't see any appetite for any amendments. And if you're wondering whether the changes that were proposed yesterday to the GDPR of a very limited nature would affect the LED, I don't think so, because they are specifically designed for private sector, so I don't think they really affect the LED. Even the public sector rules in the GDPR, I think, are not affected. So I don't think this really concerns or has any spillover effect on the LED. So that's for the first hat. And now I will put my second hat on, and I will be the postdoc at VUB. Because I wanted to introduce a little bit our ongoing fundamental research project that VUB has together with University of Luxembourg. And I want to speak about it because the LED is a very important variable for the success or the failure of that project, hopefully success. So we are a team composed of Professor Ligeti from Luxembourg University, Professor De Hert from VUB, me and Gianmarco Gori, postdocs, and our PhD student Andreas Kanakakis. And we work on a project which is called ProMode, which stands for Modernizing Codes of Criminal Procedure on Digital Investigative Methods, combining the languages of criminal procedural law, data protection law, and European human rights law. So the idea of the project came from our own experience as researchers with different types of expertise. And concretely, the idea was born in what we perceive as the lack of dialogue between criminal procedural law and data protection law for law enforcement. So the instruments like the LED. That's why we are trying to ground this project heavily in empirical research and field research in different types of jurisdictions, different criminal justice systems, in order to see what is actually important and what is actually applied by police and prosecutors and what is just nice to have. So our question is it really what matters is the Code on Criminal Procedure, the Police Powers Act, while the national law transposing the LED is nice to have, but it's not that important. Because if this is the case, that would not be sustainable, in particular in this digital era of data-driven investigations. And that's why we are focusing on techniques such as OSINT investigations, lawful hacking, AI use cases by law enforcement, because we want to see how these kind of digital investigative measures can be regulated by criminal procedural codes and data protection laws at the same time and in a meaningful way. National solutions differ. Is it more effective to embed data protection rules of the LED into the criminal procedural codes? If we keep two pieces of legislation, LED, transposition law, and the criminal procedural law completely separate, does it make the data protection law less effective? Because seemingly there are three models. There are those countries that have separate models, some embed data protection rules into criminal procedural laws, and then there are some hybrid models. And if you think in those terms, you will also understand what does Article 18 of the LED mean. It's not about allowing member states to derogate from Chapter 3 on data subject rights in criminal procedural codes. It's allowing them to transpose those obligations into the criminal procedural code. So if you have all the requirements of Chapter 3 already in the criminal procedural code, you have to legislate much less when transposing, at least for what concerns criminal proceedings. So in a way, LED actually already required some sort of reform of the criminal procedural code, and it wasn't creating space for derogations, which is, for at least in some countries, not accepted, and some are actually terrified to even listen to this. So anyway, both of these functions of mine are trying to improve and give more importance and meaning to and understanding better the LED, because those of you who know me, that my very simple mind thinks in a very simple way, which is that the LED is great and everything else sucks, basically. So that's why I'm so much interested in that. So thank you very much.
Thank you. You're right. Thanks, Uri. Yeah, I think you got some insights. Very interesting about the report, so we have high expectations. So I hand over to Teresa.
Thank you so much. And I will speak a little bit about where we come from and where we are going with the LED, and a little bit also about the challenges and opportunities. And of course, first I would like to say that anything that I'm saying here are my personal views and in no way attributable to the European Parliament. And then, of course, I also want to thank the panel organizers. I'm very happy to be here as well. The LED is a legislative instrument that is very close to my heart, and I'm very happy to speak about it, although it's been a while that I spoke about it now, so I'm even more happy. So first, where do we come from? The LED was the first horizontally applicable directive that also applied to so-called domestic processing, so processing that takes place inside of the member states, because the framework decision from 2008 that was mentioned several times now was applicable only to transmissions between competent authorities in the other member states and also outside. And now we have this directive that actually applies to everything also inside the member states, whereas before there were some member states that applied actually the 95 directive to the processing carried out by competent authorities. Others applied the framework decision, and in some member states there were actually no rules. And in 2018 I wrote the first article on the LED, an article that was very close to my heart with a person that is very close to my heart, in which we called the LED a locomotive for data protection in the area of criminal justice. And I always found this word locomotive very weird and a little bit stupid, but it's actually very true, because since 2018, the LED serves as a blueprint for a lot of data protection provisions in the area of criminal justice, and that not only at EU level. So if you do a search on Eurolex on how many documents refer to the LED, you get a list of results of over 500 documents, and around 150 of that are legislative texts. But most importantly, the EU GDPR, so Chapter 9 on operational personal data, that applies to Eurojust, Europol, and to a certain extent also to Frontex, for some processing operations, but also the data protection provisions applicable to the EPPO are very similar to the LED. And yeah, we're inspired by the LED, of course. So what I think is very important, that there's a need to keep the LED and the data protection provisions as horizontally applicable data protection framework, and ensure that any additional provisions will not water down, for example, the rights of data subjects. It's also important when we look at different legislative texts, including at international level, that were and that are being negotiated. So, for example, the Budapest Convention, the e-evidence regulation, the EU-US agreement on access to e-evidence, or the UN Cybercrime Convention. Or also, of course, what will come in the future with regard to lawful access to data. And so when we look at these standards that should be followed when competent authorities inside the EU, but also outside when it comes to international transfers, exchange personal data, I think the LED is a very good basis. So where are we now? Of course, I'm very happy, or we are probably very happy to hear that the 2026 report from the Commission will be on time, so we can speak about this next year in May. And I'm also very happy to hear that there was no feedback as to the reopening or the changing of the LED, as is the case for the GDPR. And of course, now we have a little bit more clarity, but as Jure already said, if the GDPR provisions applicable to public sector also will get more reformed, this may also have a spillover effect on the Law Enforcement Directive. And that there was not much feedback received by the national stakeholders could, of course, either mean that everyone is happy with the LED and that indeed it finds an appropriate balance between the protection of personal data and the flexibility that competent authorities need in order to carry out their work. Or it could mean that no one really cares and that competent authorities anyway do whatever they want. But in any case, I very much believe that in the future, also the LED will become much more important and visible when it comes to law enforcement competent authorities using more and more AI for their work. And of course, with regard to the report, there could be several suggestions, and we will have to see whether the Commission will still receive some feedback as to amending the LED. I would have maybe one, which is regarding the definition of competent authorities and letter B of Article 3.7 when it comes to any other body or entity entrusted by member state law to exercise public authority or public powers for law enforcement purposes. So there, maybe this is not so much needed, but of course we still then would have to be seen how we deal with the so-called Hadopi judgment. And as Eleni mentioned, there is currently a request for a preliminary ruling in case C222/25 on the question of applicability of the LED and the GDPR to processing of financial intelligence units. And when we come to the definition under the LED and the maybe more ambiguous definition under letter B of Article 3.7, we also have to take into consideration that exactly that definition was taken over by the AI Act, which could also lead to questions here. And with that, I'm coming to the part on where we are going. And I would have a question to which I don't really have an answer, but I find it very relevant when it comes to the testing and development of AI models and the application of systems. And when it comes to the question of how does data protection law interplay with the testing and development of AI and the provisions under the LED and also the GDPR on scientific research use, so Article 4.3 and 89. So for example, when an AI model is being trained and tested with operational personal data held by competent authorities, for example, in the case system, the question would be, how do we define the purpose? So what is the purpose of the processing operation? On the one hand, are we referring to the final purpose, so the prevention, investigation, detection, and prosecution of criminal offenses? Or do we actually look at the processing and the purpose at as in the very narrow sense? So the purpose is actually testing and development, and not law enforcement purposes. So that would then lead to the question, what applies, the LED or the GDPR? And in the first case, it would be the LED that would apply, whereas in the second case, of course, the GDPR would apply irrespective of the fact that the processing is carried out by a competent law enforcement authority. And this is, of course, very important because the application of either the GDPR or the LED would have an impact on the data subject rights, on the obligations by controllers, international transfers, but also the role and powers of the different DPAs. And also, when you look at the provision on research under the LED, it seems as if Article 13, so the right to information, doesn't really apply. And of course, in the GDPR context, rights can also be restricted when it comes to research, but this is much more tricky. And then, of course, we have all the case law on automated decision-making, on explainability, which was strengthened very recently again. But this, again, is applicable in the GDPR context, and for the LED processing operations, this is a very different story. And then, as I said, of course, we have the AI Act and all its transparency obligations, especially when it comes to high-risk processing systems, human oversight, reporting, documentations, logs, records keeping, and error detection. And the AI Act makes it very clear that the relevant rules under EU data protection law continue to apply when processing personal data. And they also continue to apply when data is processed for training and development. But as I said, the LED doesn't say much about informing data subjects, and in general, the provision is quite broad. And the AI Act here also doesn't really specify whether it's the LED or the GDPR applies. And so I'm very much looking forward to the guidelines on the interplay between the AI Act and the data protection acquis, and the work is currently being carried out by the Commission, and I hope that these guidelines will cover questions such as the scope and objectives of the different acts and how they interact with each other, and of course the interplay not only of the requirements and the different authorities that have to work together, but also the complementarity between the DPIA and the Fundamental Rights Impact Assessment. And of course, it would be great to hear a little bit more about the rights of data subjects when we look at the guidelines. So now I spoke a lot about the challenges, and especially the challenges to come, maybe a little bit also about the opportunities that we will have with the 2026 report, and with regard to maybe new legislation that we will adopt to use the LED as benchmark for high data protection standards. But in any event, I very much believe that the LED will be very relevant once competent authorities will increasingly use AI for their work. And in the end, very often it is about personal data, so we can learn a lot from data protection law when we look at AI and processing that takes place there in that area.
Thank you. Thank you, Teresa. Yeah. Thank you also for pointing out this research issue. I think it's an important issue, in particular if we look at all these research projects going on using personal data in this LED context. Personally, I would be very interested in the Adobe judgment, how it, the influence about that. But we discuss later with you. I'm sorry, not sorry, but I'm really happy to have a final and presentation on the adequacy decision. Last year we discussed it already. It was a bit, let's say, in the move. So let's hear what you have to say, and then we hear questions from you. Please, Nora.
Thanks so much, Francesca, and thanks to CPDP and all the organizers. It's wonderful to be back here again and to be contributing again to the panel on the LED. I will be focusing on the EU-UK adequacy decision, where we now, the key developments that have taken place since 2021 and how they may affect the approach of the European Commission and its ultimate decision in terms of whether those adequacy decisions, but specifically the LED, will be renewed. So in terms of its status, well, we are already on borrowed time. There has been an extension granted until December 2025. The official reason given for this is that we are updating the UK data protection legislative framework in the UK under the Data Use and Access Bill. We refer to it as DUA for short. And there is quite a significant focus in terms of the overall assessment of the LED adequacy decision on these reforms, which is very interesting because, of course, they're by no means finalized yet. There is what we like to call, in terms of political speak in the UK, considerable ping pong happening between our two Houses of Parliament, the House of Commons and the House of Lords, in terms of when this bill will actually be finalised. And it had been hoped that it would be finalised by Easter, but here we are going in very close to the summer recess. So it was very prudent and sensible for the European Commission to grant the extension on that basis, because otherwise there would be a whole set of reforms to the data protection framework that they wouldn't be taking into account. On the other hand, we still have no guarantee that this bill is going through, so we'll have to see what is ultimately going to happen in December in terms of the ultimate assessment. But there's a lot of confidence about what the bill is going to mean, even in its unfinalized stage for the granting of the adequacy agreement. So commenting on the proposed extension, the EU Commissioner for Democracy, Justice and the Rule of Law and Consumer Protection, Michael McGrath, said that both adequacy decisions, the GDPR and the LED, are key to the relationship with the UK. They ensure data can flow freely and safely, which is crucial for trade, justice and law enforcement cooperation. And the proposal will allow the Commission to assess whether to renew these decisions based on a stable legal framework while keeping data flows to the UK uninterrupted. So that particular reference to this test of stability is quite significant, and it actually speaks to the overall approach of the Commission that it adopted when it granted adequacy back in 2021, which is actually quite a narrow interpretation of Article 6 and the essentially equivalent standards under the LED, especially when you compare it to the standards of the Court of Justice, which is where those essentially equivalent standards come from the Schrems judgments from 2015 and the related case law such as Schrems 2 thereafter. There is an equal amount of confidence from policymakers also in the UK. The UK Data Minister Chris Bryant said that data adequacy is 99% certain to be renewed as soon as the bill receives parliamentary approval. So again, we have a lot of confidence that this is going to happen before the adequacy assessment even takes place. So how have we reached this point? Where has all this confidence come in terms of these policy-making approaches? Well, we've had some key developments since 2021. Of course, we have the DUA bill that I just mentioned. What's quite significant about this particular set of proposals amending UK data protection law is that they're much less concerning from an EU data protection acquis standpoint. There are far less significant changes to data protection principles, rights, than in previous proposed legislation, such as the Data Protection and Digital Information Bill. So there is, shall we say, quite a significant sense of relief that it won't have the same impact, it won't have the same level of divergence, depending on how it is ultimately finalized. Secondly, and this is probably much more significant in actuality for the Commission's assessment, the game changer is that the UK is no longer withdrawing from the European Convention of Human Rights. This was a real, meaningful threat back in 2020. It was reiterated on several occasions by the previous government, and it would have jeopardized not only both adequacy decisions under the GDPR and the Law Enforcement Directive, it also would have jeopardized the Trade and Cooperation Agreement, specifically Part 3 for law enforcement data processing and judicial cooperation, and also the Good Friday Agreement concerning peace and security in Northern Ireland. So the fact that that has now been taken off the table has meant that the political mood music has swung drastically, and we are in a very different political and geopolitical space. But we've also had fresh concerns regarding another piece of legislation which is highly relevant to the adequacy agreement of the Law Enforcement Directive, and that is not the reform of the UK's Data Protection Act of 2018. This is a totally different piece of legislation, the UK Investigatory Powers Act of 2016. In particular, recently, there's been very close scrutiny of the implementation by the UK government of the provision on technical capabilities notice. Now, that sounds very dry in terms of its language, but it is at the heart of a legal challenge being brought by Apple against the UK government, where Apple is alleging that the order itself is amounting to them being requested to provide for a backdoor and to undermine very sensitive and important levels of encryption to their cloud storage service. This case is ongoing. Actually, for months, we didn't have any official acknowledgement of the case because of the national security implications. The UK government wanted to keep it that way, but the Investigatory Powers Tribunal, the court that will be overseeing the case, in its hearing last month, said that it wasn't proportionate to withhold all of the details of the case, and they made it publicly known that Apple had brought a challenge, and the hearings and details of those hearings are going to be confidential now and heard by the Investigatory Powers Tribunal going forward. But we also know that there'll be other relevant data protection experts being consulted for that, including a representative, for instance, from the Information Commissioner's Office. So what does this all mean moving forward for the implications of how the Commission will approach the adequacy decision? Well, as highlighted in quite a lot of detail by the European Data Protection Board in its 2021 opinion of the adequacy assessment granted previously, the Commission adopted a very narrow scope of review for the adequacy assessment. It took a very narrow interpretation of the essential equivalence standards under Article 36. Notable omissions in the adequacy decision included any close scrutiny of the Investigatory Powers Act, for instance. The focus was very much on the key elements of the Data Protection Act of 2018 and the overall institutional architecture for oversight. So if you were an academic and you were maybe having a bit of a bad day, you tell the student that it was very well researched, but this is highly descriptive, and you tell them to go back and resubmit a more substantive assessment. But in this case, if you read an assessment like this by a court, you would say that it was hugely deferential to a particular member state because the level of scrutiny involved is quite general, and it really doesn't focus on the application of these legal standards or of their oversight in practice. And this may make sense in terms of the particular very narrow approach that the Commission has decided to adopt in adequacy decisions more generally. And in terms of there not being meaningful, detailed engagement with the Investigatory Powers Act and the Law Enforcement Directive adequacy decision, you could argue that it was mentioned in the GDPR adequacy assessment. But the argument would be that it was relevant to both, so it should have been mentioned in the GDPR adequacy assessment, but it should have been examined in much more detail, all of the investigatory powers that law enforcement can use for countering serious crime under that particular piece of legislation. The European Data Protection Board also highlighted that there was a lack of focus on scrutinizing the independence of relevant oversight bodies for law enforcement data processing in the UK. One, of course, is the Information Commissioner's Office, and the other, less well-known, is the Biometrics and Surveillance Camera Commissioner. So, for instance, under the Data Protection and Information Bill, the very problematic piece of legislation that we had back in 2021, that particular commissioner's office was going to be entirely abolished. That is no longer the case under the DUA bill, for instance. But it's also worth noting that all of the oversight responsibilities and also the monitoring responsibilities of the Biometrics and Surveillance Camera Commissioner, which oversees and generally provides annual reports on the exchange of data between the UK and the EU in terms of biometric data, passenger name recognition, for instance. None of that has been taking place in the past 2 years because we haven't actually had a commissioner in post in the UK since last August. The question is, are those gaps in actual implementation and oversight, will they be engaged with by the Commission in terms of how this institutional architecture is working in practice or is falling short of the essential equivalence standards? And just another specific example of where there could be closer scrutiny in the upcoming law enforcement adequacy decision is on passenger name record data. Very important to consider another development, which has been the fact that because we have the Trade and Cooperation Agreement, Part 3 of that and the overall agreement is going to be reviewed in 2026. So there have been ongoing meetings and monitoring sessions by the specialized committee appointed underneath that particular framework. And every time that they have met, they have provided just the minutes of these meetings for public accessibility. It would be good to know if the European Commission will be able to rely on the full reports of those meetings in terms of informing its adequacy assessments with the GDPR and the Law Enforcement Directive. A key question, for instance, will be the delays in implementing certain requirements under the Trade and Cooperation Agreement, such as the deletion of passenger record name data of EU citizens once they leave the EU, because the UK is now a third country. So the same standards that we had for Opinion 115, that landmark Court of Justice judgment, now apply to the UK. And they should be deleted on departure, subject to the test of, does this individual pose a risk related to terrorism or countering serious crime? So overall, to conclude, what will be very key to scrutinise in the next adequacy assessment that the Commission does for the EU-UK LAD adequacy assessment will be how much it is a rule of law rights-based approach, or whether it will take a much more holistic approach, as it did for its first 2021 assessment, which will encompass not just the rule of law and human rights and potentially some reference to the Court of Justice case law and the case law of the European Court of Human Rights, but how much it will focus on other considerations such as the political, economic, and security geopolitical landscape we currently find ourselves in, where there is a real pressure to be maintaining close security cooperation between the EU and the UK. But the argument would be that this should not come at the expense of data protection or the protection of fundamental rights. Thank you.
Thank you, Nora. Very interesting, and thanks for keeping us up to date on these assessments. I think you heard a lot, and I know we now come to the questions of the public. I will not misuse my role and ask questions, although I have a lot. So you heard a lot about the case law, about the application report, about the challenges and opportunities, and on the adequacy decision. So I will open up the floor for any questions, maybe now, and otherwise I have a lot, but I don't want to misuse my role. Yes, please.
Well, thank you very much for this interesting panel, very interesting updates concerning the LED directive and the cases and within the context of the European Commission. My question to you is much more like in the sense of the international context. I know the European is trying to comply with many of those international frameworks coming in, especially, well, the second additional protocol of the Budapest Cybercrime Convention, the UN Cyber Crime Convention. And most of those instruments actually try to strike a balance on the need for law enforcement investigative authorities when it comes to cyber-enabled crimes investigations to actually protect, conditions and safeguards and protection of fundamental rights. So my question to you and to all of you is, what are your views on this? What's the role of the EU institutions, and specifically member states, in actually making sure that these things that you have been already discussing within the context of the LED directive might actually trigger an application within the international context? And the second thing is, we need to think that many of the crimes that are committed today are being assisted by artificial intelligence. So we have like this one other element of the complexity of the different AI providers, deployers, exporters, which is a whole ecosystem on itself. And we will need the cooperation of those entities to investigate not only cyber-enabled crimes, but crimes in general that are conducted through AI. So my question to you is very much in that regard. What are European institutions, and specifically, well, I would also like to hear the view of the United Kingdom on this issue. Thank you.
Thank you. So basically, maybe we start first with an answer. Is someone there who wants to answer maybe the first questions on the EU institution application in an international context? Maybe Uri or...
maybe you're right. Yeah. Okay. Yeah. So sure. I think obviously our objective is that we preserve the LED as I said before, as a locomotive, right? So we want this to be the standard for data protection in the area of law enforcement. Of course, there are. Whether it's going to be a golden standard or a global standard or whatever terms were used for the GDPR in that sense, it's not really important for us. What is important for us is that this is the standard. And if we can spread it globally or outside of the EU borders, we don't have a problem with that. We already have it applied in the Schengen associated countries. We had, well, at least we had in the UK the very good transposition of the LED. So maybe that one can survive. I don't know. That probably you know better than me. So anyone who wants to cooperate in the law enforcement area, exchange data with the EU, you know, the easiest way is to get as close as possible to the LED standards. But as you rightfully said, there are other data protection standards in the area of law enforcement that are global. For example, Convention 108 Plus of the Council of Europe, or the dedicated provisions. I think it's Article 14, if I'm not mistaken, if I forgot the exact number, but I think it's Article 14 of the second additional protocol to the Cybercrime Convention, also Council of Europe. Now there is UN Cybercrime Convention. All those instruments, they don't have the level of detail or the level of protection that the LED has. So in what is our interest, obviously, is that if EU member states adhere to those instruments, that they actually, that doesn't mean that they can lower the standards that they have already adopted by adopting the LED. So in that sense, obviously we want to enable data exchanges and law enforcement cooperation. There are ways how to do it. I don't have space here to go into details. For example, in the context of the Budapest Convention, which data sets can be exchanged and how, etc. There are limited possibilities there and certain safeguards embedded there. Also for cross-border cooperation with service providers. But which means also that there are instances where, foreign third country law enforcement authorities could ask European service providers for certain types of data, again, in a very limited sense. But in any event, whatever our law enforcement authorities are doing, our meaning EU law enforcement authorities are doing, has to be in compliance with the LED. So if they are a contracting party to the second additional protocol of the Budapest Convention, they can do so, but that doesn't mean that only the safeguards from the Budapest Convention apply, and in that context of international cooperation, and that LED doesn't. LED is the standard, and it cannot go lower than that.
Okay, thank you. Nora, do you want to add something?
I'll very quickly add just one point regarding, in response to Yora's point about the Law Enforcement Directive. I would say that in terms of its transposition to the UK, that the UK adopted that wholesale in addition to the GDPR under Part 3 of the Data Protection Act of 2018. And while there were quite a few concerns by commentators, academics, including myself, about what previous legislation under previous governments could have done to undermine the safeguards that the LED brought into the UK Data Protection Act, we wouldn't have the same concerns regarding this new forthcoming DUA bill. Having said that, the concerns again focus on, and you already mentioned this, but data protection on the ground in practice, in particular, its enforcement and oversight. So there's been some concern regarding the approach of the Information Commissioner's Office, the UK's Data Protection Authority, and its approach to enforcement, where there have been data protection breaches by law enforcement bodies in the UK, and taking approach where fines are just off the table, and it's a more conciliatory approach in terms of encouraging compliance in future. And there are quite mixed feelings in terms of whether less enforcement of more significant penalties is the way forward, but I guess that's a wider question for data protection law enforcement for the LED across the EU. And just to add another point to what you're saying about, how does this all get implemented in an efficient way, I think one of the greatest challenges is something that Teresa already mentioned, and it's the fact that there's such a complex European digital acquis when it comes to law enforcement data processing. And recently, but not just, now we have the AI Act, and there's going to be guidance coming down as to how that's going to interplay with the GDPR and the Law Enforcement Directive. But one of the key challenges here is that assessment, mapping what's actually happening on the ground. And there's a real lack of not qualitative statistics, but quantitative statistics as to difference in safeguards and divergences between member states and different frameworks. So it's really good to hear that the European Commission are working more closely now with other EU agencies, such as the Fundamental Rights Agency, to be gathering more information as to how it's being implemented on the ground.
Thank you. Maybe briefly to the second part of the question, the cooperation. Yeah, I know. Just one last answer maybe to the second part of the question regarding the cooperation with providers, with private parties on AI crimes.
Well, I think the question was much broader than that. I think you managed in one line to bring the thousands of issues, because we can have AI impacting not only the types of crimes that will change with the use of AI, but also how AI will enhance the tools, how will it affect cooperation between the authorities, investigations, etc. So I don't have an answer on this. Already we touched upon during this panel on potential impact on of the AI. Definitely one of the issues that we see is that we need much more scrutiny, and I'm not sure exactly about the types of measures that we need to take on the limitations of using AI when it comes to its use for law enforcement purposes, not only from competent authorities, but also from private companies, because there is enhanced cooperation between law enforcement authorities and private companies. The fine line, when do you move from a corporate context into a criminal investigations context, etc., that's huge. But also, let's not forget the fact that AI can be a very important factor that will make more severe crimes. Like we have been working with, I know it's a trivial example, like child pornography and virtual child pornography, but now AI brings all this to another level. So a lot of the considerations that have been around for many years in terms of criminal law, they are really discussed under a different veil at this moment. So I think we can have a complete panel on this in the future.
Yes, maybe next year. Yes, please.
Okay, thank you. My question is about scope of application, and I read almost all European Court decisions about data protection. I know Bulgarian case, but the issue is every country has some kind of criminal conviction register or records, and this register is used for different purposes. One is, for example, for criminal investigation, but there is other purposes. For example, if you want to go to Swiss to work, you need to take a paper that you are not convicted, for example, or if you want to work as a judge, you need to take information that you are not convicted before. So how do you see this application for the national registers of criminal records? Can it be double application of GDPR and or how to deal with this and with data protection principles that is a little different in one another case? Thank you.
Thank you. A very specific question, but always on the use for other purposes, on the fine line between the GDPR and the LED, which is not that easy, because I think, Teresa, you spoke about it. Would you maybe?
I mean, yes, I think this is a problem in many member states where there, and also the case law doesn't make it easier, the recent case law, to know about the application. But I think, first of all, you need to look at the purpose of the processing and the authority that processed the personal data, although that, of course, now got a little bit broader. But I do think that both the Law Enforcement Directive and the GDPR can apply. So you're looking at the purpose, whether it's done for Article 1.1 of the LED, for the investigation, detection, prosecution of crime, or if the processing is carried out for GDPR purposes. Of course, if we now look at this Hadopi judgment, everything is getting a little bit more difficult to actually know who can apply the lead to certain processing operations and how far this can actually be stretched. We now wait for this new preliminary reference, and I was mentioning letter B of the Law Enforcement Directive, which also opens and broadens the scope for interpretation on when additional authorities can apply the Law Enforcement Directive to their processing operations, and how far you can go back and saying, this was also done for prevention, or this processing operation was done in order to, in the future, prevent certain criminal activity. So I think this application of the lead was and is interpreted in a very broad sense. And as you mentioned, of course, this has consequences in terms of the rights that apply and the restriction of rights. Then you need to look at how this was transposed in the different member states, how you can restrict the rights. That I think is also a question in this preliminary reference. But also the obligations that apply to controllers, but also to processors. And there, I think there are also a lot of questions related to processors of competent authorities in the member states. If we look at international transfers, or I think Eleni mentioned that, of course, everyone was very much concerned about the GDPR, and I think this was also the case for national DPAs, that everyone was focusing and giving all the attention to the GDPR, whereas for the Law Enforcement Directive, it only came after a certain while due to the transposition or the delayed transposition, and due to the fact that there were a lot of new obligations under the Law Enforcement Directive. So I think this will develop also more and more in the future until we figure out where the Law Enforcement Directive applies and where actually the scope of the GDPR will then be applicable.
And Eleni wanted to comment.
Yeah, and if I may, I definitely expect to see more judgments like the pending one on the financial intelligence units and the scope of application. How do we apply the lead? Do we apply the GDPR? Exactly, because there are in practice many cases like the one that you are explaining. And I have to proudly say that even people on this panel, we agree to disagree on this topic for years. So we are all...
On FIUs, for sure, yeah.
I think it was 2022 or 2023, we were on a panel, and it was here at this conference, it was the chairperson of the Belgian FIU, exactly on this point, who literally said, well, we apply the lead, others apply the GDPR. One day, the Court of Justice will decide, and now we are actually expecting the Court of Justice to decide. So remember this, and we will, in the future, we will see many more judgments on this.
Okay, maybe we have one final last question in the back, and then we have to close this early morning panel. No, really, better than expected.
Hello, my question is regarding the intersection between AI and the lead. Do you think that the lead, lack for a better word, strong enough to encourage public trust? Because the AI Act, of course, has the exceptions and all of that stuff, and during the conference, we learned a lot of the challenges, discrimination, transparency, all of these challenges that AI bring. I'm wondering, do you think that the lead can encourage public trust? Do you think that it's enough to encourage public trust as we move forward and we adopt this type of technology in this age?
Yes, thank you for the question. Is anyone, do you want to answer to that? I think it's a very valid question. Yeah, public trust is not something we can ignore.
I'll bleed in very quickly.
Yes,
I'm sure there'll be other comments to make as well. I mean, I would stress that the Law Enforcement Directive was such an important piece of legislation that got introduced as part of the EU data protection package, because previous to that, there was a culture within law enforcement and member states that data protection simply just didn't apply because of those exemptions and restrictions under the 1995 directive. Now, of course, we had the Council of Europe Convention 108 from decades before, from 1981, but there really was a very pervasive culture that data protection just wasn't applicable. So I think the Law Enforcement Directive plays a very significant role in playing a foundation for safeguards and standards, for automated processing, for those ever more sophisticated AI systems we're going to see during the future. And I think it's very, very important that in the AI Act, you see references everywhere to the Law Enforcement Directive in terms of the fact that it's still applicable, whether or not we have a gap here in terms of compliance. Due regard has to be given to the Law Enforcement Directive. I would just make a very quick point in terms of the fact that I think that we should try and avoid putting ourselves in a situation from the perspective of public trust, whereby all of our issues of interpretation and conflict get left until there's a court of justice judgment. I think that is a really problematic situation that the EU data protection acquis has gotten itself into. And that allows me to now tell you about a shameless book plug, which I'm absolutely required to do for my book publisher, which is that this has been very much prevalent in the area of EU data retention law. And I was expecting to see another edition on EU data retention law that Eleni Costa is the editor of here, because we had a book stand last year here for the LED commentary.
Yeah, I didn't bring a copy.
You didn't bring a copy, but it's up in the bookstore, right?
Yay.
So there is an edited copy on.
There are many people in this room that actually contributed to this data retention book.
Yes, so there's an edited copy, and then as a companion piece, I'll also be publishing my book on EU data retention law as well this summer. But it very much makes that argument over and over again that the fact that we end up having to go to the Court of Justice to resolve these issues of fundamental rights conflicts and gap analysis means that there are clear issues with baking in fundamental rights protections in the law as it stands. So that is something that we really have to address, because in the meantime, while the years pass, there's so much legal uncertainty as to what standards apply, and that will inevitably have an impact on public trust. There's no question.
Thank you. So maybe we close with these recommendations, and I really thank you for coming this early to this very intensive panel. I think we had great experts on the LED, and I just wish you a nice day at the CPDP, and thank you a lot for coming. Thanks.
Thank you.
And my panelists. I thank you as well. Yeah.